guns and money.
Let us start with Masai Ujiri. Just a quick background for those not following the story. Masai Ujiri is the general manager of the NBA champion Toronto Raptors. So it's not just that Masai Ujiri is the general manager of the Raptors. Important for the story, he's an African-American. He's one of the very few in the NBA. So last year during the 2019 finals, the Toronto Raptors won the NBA championship. I believe it was game 6, but hopefully I'm not wrong on that. But they won in Golden State, so they won at the arena. So there's a video that was not available to us until this past week, but a video that shows Masai Ujiri after the Raptors won, Kawhi Leonard, Kyle Lowry, they're all celebrating on the court, and Masai is trying to come onto the court. And before he gets to the court, he's stopped by a security guard. That's Mr. Strickland, who's a plaintiff in this case, stops him. There is an altercation that ensued. Dan, I won't talk about the video yet. I'll leave that for you. But as a result of this incident, Mr. Strickland was alleging personal injuries. He alleged that he was assaulted. He alleged that Mr. Ujiri was the aggressor. Mr. Strickland, I think, important for the story, is a Caucasian. And that was the lawsuit. It was an assault lawsuit. Masai Ujiri was being hit with allegations of assault, causing injuries to Mr. Strickland, that he wasn't able to work. And that's really where we're at for about, I want to say about a little over a year. So Dan, let's fill our listeners in. What's the new development and where we go from here?
Yeah, sure. Well, it underscores the importance of discovery in federal court litigation. I mean, the lawsuit that was filed by Alan Strickland alleged that Ujiri pushed him twice and initiated the contact. And of course, Ujiri, in his answer and affirmative defenses, painted a somewhat different story, that the aggressor was the security guard. So one of the wonderful things about our litigation system is that both sides get a chance to test the veracity of the other side's claims. And the body cam that was on Officer Strickland, I don't know if he was uniformed or not that night, because it seems
He was.
He was in uniform, and I guess acting under the color of state law by being an Alameda County Sheriff's Office deputy. He was wearing a body cam while he was on duty, and the tape from that body cam must have been requested by Ujiri's legal team during discovery. And the reason this is surfacing so many months later is that that's how discovery works. It takes, you got to file requests for production, and there are little ensuing battles over whether something should be discoverable. But the videotape bolsters Ujiri's assertion that he was not the aggressor, that it was the security guard, it was the officer who shoved him twice.
I'm going to go one step further, Dan. It doesn't just bolster Ujiri's case. It just shows that Strickland Ujiri didn't push him twice. There were clearly two pushes, but from the other side. It's just almost as if Strickland just said the other version of events. He said that Ujiri pushed him when it was actually Strickland clearly being the aggressor twice before anything happened.
Yeah, well, I think you're right. But what this really kind of, not bolsters, but what this really highlights is the procedural posture under which this arose. Ujiri's legal team filed not a new lawsuit, not a new answer, not a counterclaim, but they asked the judge overseeing the case for permission to file an amended answer and counterclaim. And the reason they did that was that this case is pretty far along, and there are usually in federal court cases these case management orders which set out a lot of deadlines and timelines, and usually there's a hard and fast deadline in which to file amended pleadings. And in this case's case management order, it doesn't provide any kind of date certain. It just simply states that amended pleadings shall be upon good cause only. And I would think, given the substance of what the videotape shows, it would certainly establish, at least in my mind, good cause. But the other consideration here is that the trial of this action and all of the important benchmark dates in this lawsuit are in 2021. I mean, you and I have litigated not against each other, but we've had our fair share of—
Not yet, Dan. Not yet.
Not yet, but we're working on it. But our experience, or at least my experience, has been that in most straightforward federal court litigations. They are on a standard track where you get 6 to 9 months for discovery and a trial, roughly a year after the commencement of the lawsuit. But check out the case deadlines in the Ujiri-Strickland case. The trial isn't scheduled until December 2021. The discovery cutoff date is in April of 2021, and dispositive motions are due in July of 2021. So what that tells me is that lowers the bar significantly for Ujiri's motion for leave of court to be granted, because not only does the substance cry out for good cause, but I think the very relaxed schedule in which this lawsuit is proceeding really leaves ample time for the parties to pivot into this, with this new information without unduly prejudicing other side or unnecessarily delaying the court schedule.
So a couple things, and I think it's important to note, Dan, I've been following this. It's probably about a year since this has kind of come on our radar, maybe a little bit less, maybe November of last year. There was a period of time where I did a couple media interviews. The video wasn't coming up, and I know there was some indication that maybe the video wasn't available. The body camera footage wasn't recording. The body camera footage had been deleted. I'm not sure why that was out as potential reports, but just kind of important to note, there's a concept in the law called spoliation. To the extent that you have some type of evidence and you delete it or you dispose of it or you overwrite it, that's what would enable you to get an adverse inference in the case. So I'm not sure necessarily why that was out, but I guess important, don't believe everything you read in the media. I mean, this is not coming out until, a year into litigation. So as part of this motion and this request to file a counterclaim, Ujiri doesn't really hold back, and I posted at least a little snip of the counterclaim on my feed, but I'm just going to read you a first sentence. I mean, this is when you bold and underline something, that's you want the judge to pay attention. I'm just going to read you paragraph 2 of the counterclaim. In fact, Mr. Strickland's version of the 11-second encounter he had with Mr. Ujiri after Game 6 is, in all respects, a complete, that's bold and underlined, fabrication. So when you use words like that, Dan, and we've talked about this kind of on the Zion Williamson front, I mean, this is getting very close to something that should, and you would know better in terms of federal litigation if you can get it, but where costs should be available to the other side. If this is a complete fabrication and you delayed in giving over the video, I can't imagine a better situation where that in theory should be available.
Well, you raise a great point, and it leads me to my next question I'm going to pose to you. I mean, this isn't
I'm so excited.
Yeah, this isn't even discovery. These are initial disclosures, right? Mm-hmm. Initial disclosures in federal litigation basically occur relatively early. You don't have to wait for a request. You basically supply all of the evidence and documentary evidence, tapes, and whatever that would tend to support your claims or defenses. So this is material that arguably Strickland's attorney should have turned over early on. So it begs the question, Dan, given that this information and this evidence comes from Strickland's own body cam, this to me raises the specter of Rule 11 sanctions against the attorneys for Strickland that signed the federal court complaint, that allege or that assert that Ujiri was the aggressor. So what do you think about the prospect of sanctions here?
So a couple things, and I think it's probably important to give one level of background to this, just so people are aware. I mean, part of my background with the Giants that Dan mentioned, I worked in public relations. The non-sexy part of my job was issuing credentials to appropriate personnel and then reviewing them, different color credentials to get in the field, different access. So the initial story here, pre-lawsuit, was that Ujiri was trying to get to the court without showing his credential. And to the extent, right, if you're just some random guy, even if you're wearing a suit, and Ujiri was wearing a suit, which is important, not everyone's wearing a suit at an NBA game, so that should have probably given you some cause. But Ujiri, I guess the allegation was Ujiri tried to get to the court and didn't show his credential. Now, if we watch on this video, Dan, it's very clear that as Ujiri is walking over, he's reaching into his shirt for something, and actually, as he's pushed either the first or second time, the credential actually comes out. So
that's and then a good credential. It pops out on contact.
Well, no, the lanyard popped out, not the actual thing. But also, if you're just watching the court, there's an NBA player that then comes over. I don't know if it's Lowry, but maybe it's even Kawhi, but I'm not sure who it is. But they come over and they get Ujiri. So on all levels, Dan, it's pretty clear if you watch the video, Mr. Strickland realizes he messes up. He messes up either when the credential pops out or when the Raptors player goes to get him, or Dan, when you just pushed an individual for 2 times for no apparent reason. Ujiri was not being hostile. So by all indications, this does appear to be a violation. And I have to imagine, Dan, his attorneys saw this video, unless Strickland, the only version I could say that you get the attorneys off the hook is if Strickland was hiding this video the whole time. And it's now only the first time is today or this past week or so when Strickland's attorneys saw it. But they had an affirmative obligation to, I think, as officers of the court, to advise the other side of this as soon as they saw it.
No, well, the body cam is the property of the Alameda County Sheriff's Office. I don't think this was something that Alan Strickland had within his possession. And if I put myself in the position of the lawyers who are certifying that the complaint, is basically the factual contentions are backed by evidence or will be backed by evidence following a reasonable opportunity for discovery. I mean, the lawyers that filed this, it's a major law firm in Sacramento, California. All they do is personal injury and employment law, 50, 60 attorneys. They've been down this road before. They're not newbies. So I would think that when they filed the complaint, they probably didn't have reasonable access to this body cam. Otherwise, they never would have taken it.
I'm going to agree with you. I'm going to agree with you because I'm just from, Dan, 90% of my cases are just pure civil litigation cases. Mm-hmm. I have the defense of those cases. Sometimes I have some of the, I take them on the prosecution side. You don't always have all of the evidence. So, if Strickland was saying he pushed me twice and that's all you're going off of, and you have to make a version of a request to get something from his employer, I don't necessarily think, I think the lawsuit, Dan, was filed, I believe, at the end of 2019, and this incident happened in June. It's kind of a quick turnaround relative to how the sheriff's county, the sheriff's department might work. It's very possible they didn't have it, but I would think, COVID didn't hit until March. I would think they would have it sometime, February, January. It doesn't really make sense to me that this is the first time they've seen it.
Yeah, because if you're the Sacramento law firm that filed this case, the first thing you ask your client is, would it be okay if we, if we took a look at this body cam, and would you ask your employer, would you waive the, any kind of objection to it? And as an attorney, I'd want to see this body cam. So it really does place the lawyer in a difficult position, because if there's that amount of time that was spread between the game and the filing of the lawsuit, there would reasonably have been ample time for the attorney to conduct his due diligence investigation. So, maybe we're looking at a Rule 11 motion coming down the pike in less than 21 days, because as you know, under the guidelines, you can't file those right away. You have to allow a cooling off period in which to give the other side an opportunity to withdraw the offensive pleading. And this leads me to my practice tip for you young ones out there who have crazy clients or clients whose stories may not add up. And this happens a lot in family disputes, partnership disputes, divorces, personal injury cases. If you're a junior associate, do not be the signatory of the complaint. Allow your partner, the supervisor, to be the signing attorney, because I could tell you from personal experience, being the only person to sign the complaint carries with it a risk that you could be the one left holding the bag.
So I think kind of one interesting note that I don't want people to take for granted in the story, and Dan is right. It's not the first time in the history of the law where someone made a claim that we'll say wasn't necessarily true, but of that, we'll say that like Venn diagram, right? If there's the people that aren't necessarily true, there's only a very small subset that there is some type of evidence, be it video evidence, documentary evidence, that completely contradicts their case. I mean, there's a whole industry of people that we'll say having claims that are loosely insurance fraud, but there's nothing really to back it up. But this is, to Ujiri's extent, and I think important to bring up. Ujiri had a comment that I took a lot away from. Ujiri, was saying if this had happened to somebody else, right, that didn't have the means or the profile or the stature that I do as there's a Toronto, Raptors GM. I mean, it's great for me, but he goes, it's just not fair that it took my resources and my level of stature to avail myself to this kind of defense. I'll push back on Ujiri's comment a little bit because, Dan, as you and I are pointing out, this is just basic federal discovery. For their failure to disclose this would have been unethical, would have risked sanctions with the bar if they didn't provide this. So I think the video doesn't really have anything to do with the quality of his own lawyering. But I will say, I understand the point that he's getting at, but I don't think, Dan, if you had like, Mr. Magoo as Ujiri's lawyers, the video still would have come out. It's the affirmative obligation in federal court for the plaintiff to provide those materials. It's not like in most cases in state court where you actually have to make a discovery demand to get the video. This is more one-sided that Strickland's attorneys had to provide that on their own.
Yeah, I'll leave you with one. And before we move on to our next topic, I want to leave you with a prediction here.
Wait, time out. Do we have a special sound effect for your predictions? Because you're like undefeated in these.
I'm on a roll. I mean, I'm fresh off
Dan
the heels
Stradamus.
of The Rock having some insider claim creditor issues. I'm going to move on to my next prediction. We haven't seen the amended answer. I'm not sure if the amended answer was filed as an exhibit here, but if leave to file one is granted by the court, I wouldn't be surprised if Ujiri adds a Section 1983 claim and brings in the Alameda County Sheriff's Office under a Section 1983 municipal liability theory based on failure to train, failure to adequately supervise. I mean, when you see some of the public comments that have come out from the Sheriff's Office, they instead of agreeing that this looks really bad, the Sheriff's Office's public statements still support Alan Strickland, and the spokesperson who is quoted said, well, it only shows snippets of what actually happened. It needs to be viewed in context. And if I'm Ujiri and he was wearing a uniform and there's some training deficiencies involved here, and maybe there's a track record where he wasn't adequately disciplined in the past when he should have been, maybe this could give rise to a muni liability claim under a Section 1983 theory. So that's my dark horse prediction for this case coming down the road. I know it's a real long shot, but I think it might fit here.
Well, Dan, you're always right. So, I mean, it's not really a dark horse. It's just inevitable at this point.
I mean, I could make the easy predictions. This is one that's not the chalk. That does require some thinking outside the box. And having done my share of Section 1983 litigation on the civil side, I think you could at least get a failure to train, failure to supervise claim beyond a motion to dismiss. So let's move on.
Dan, before we move on, no one on the podcast will see this, but I'm snapping my fingers like Thanos. It's inevitable. I'm inevitable.